Welcome to Kelly Dry's At Low Access podcast, and this is Simone Roach. Recently, Washington Attorney General Nick Brown, a bipartisan coalition of attorneys general from 10 other states, and the California Department of Financial Protection and Innovation wrote the Consumer Protection Financial Bureau's acting director, Russell Vought, pressing the CFPB to issue long-delayed restitution to consumers allegedly harmed by a business offering online training for tech positions. The letter details an investigation brought by the CFPB and the 12 states, collectively the states, against Pre-Hired LLC for making certain earnings claims and employment guarantees and for using allegedly abusive debt collection practices. The CFPB and a similar, though not identical group of states filed a bankruptcy court proceeding against Pre-Hired, alleging that the company violated the Consumer Financial Protection Act, Truth in Lending Act, and Fair Debt Collection Practices Act. In November 2023, the court ordered Pre-Hired to return over $4.2 million to over 660 consumers. Because Pre-Hired was in bankruptcy and unable to issue refunds to consumers, the refunds were to be sent from the CFPB's Civil Penalty Fund, which under 12 CFR Section 1075.103 offers funds to compensate harmed victims. The states now assert that even though a year has passed since the CFPB finalized the allocation of funds in May 2024, the agency still has not issued any consumer checks. According to the letter, the CFPB stopped providing substantive responses to the state's correspondence in February 2025 and has not provided any response to a March 2025 email from the states asking about the status of the distribution. The letter requests that the CFPB provide the status of the refunds and urges the Bureau to prioritize the matter. The state's letter is another example of attorneys general alleging consumer harm in the wake of ongoing reductions at the CFPB. And we previously wrote about a multi-state amicus brief filed in support of the CFPB that warned of these very concerns and cited this case. For example, that brief detailed the frequent partnership between states and the CFPB and predicted that the CFPB's absence will leave the Civil Penalty Fund inactive, even though consumers have yet to receive compensation from the Civil Penalty Fund in more than a dozen matters, including the Pre-Hired matter. And while we expect states to largely fill the gaps left by the CFPB, the state's letter demonstrates that some gaps may remain nonetheless. That said, expect attorneys general, particularly Democratic AGs, to continue to make these challenges public as they push back on the new administration. And if you'd like more information on what you've heard on this topic, please contact either Paul Singer, Abigail Stempson, Beth Chun, or Andrea deLorimier, and you can find their contact details in the show notes. And also, please see our Advertising and Privacy Law Resource Center available at kellydry.com.